When a student is charged with violating their university student conduct code, what are some inherent dangers for a student participating in such a process? The answer to that question is coming up right after the intro. Welcome to Gustitislaw. I'm Steve Gustitis, and this is my channel. At Gustitislaw, we discuss issues related to managing encounters with the police, effectively navigating the criminal justice system, and how to defend criminal charges. If you're new to Gustitislaw, I post weekly videos concerning these topics, and I encourage questions. I encourage comments in the comment section below, and I will respond to them for you. This video is part one of a new three-part series on the dangers of the university student disciplinary hearing process. Links to other videos in the series can be found below in the description section. Today, we will begin our discussion about the first two dangers inherent in this disciplinary hearing process. Number one, when a student receives a letter from their university alleging that they have violated some aspect of their student conduct code, oftentimes the student's inclination is to sweep this problem under the rug and just hope it goes away. Oftentimes they fail to tell their parents about these allegations that have been made against them, and consequently the student fails to seek out help. The right to a qualified advisor is foundational in these disciplinary hearings. And when a student fails to seek out help, they fail to obtain the qualified counsel and assistance from an advisor, whether it be a parent or an attorney, to help shepherd them through this difficult and oftentimes frightening university process. Regretfully, I have spoken to many parents whose child have done just that. They've received this letter making allegations against them. The student fails to seek out qualified assistance from either their parents or a trained advisor. They try to handle the problem by themselves. They go through this process. They end up being found responsible, and then they are sanctioned by the university. It's at that point in time they tell their parents, and that is when I often get the call. However, at this point in time, it's often too late because the student's ability to defend themselves at that point in the process is severely limited by the limited ability to appeal. The second danger inherent in university student disciplinary hearings is the low burden of proof. Federal law offers students the barest of due process rights in these hearings. Most universities employ the preponderance of evidence standard. The preponderance of evidence standard means that if 51% of the evidence suggests that the student is guilty of violating the student rule, then they are typically found responsible and then sanctioned by the university. This is a far cry from the system and standard in the criminal justice system, where guilt must be proven beyond any reasonable doubt. All the more reason why a qualified advisor should be sought out and consulted with before the student attempts to defend themselves in these university hearing processes. Don't forget to add your comment or your question in the comment section below. I will respond to those as quickly as possible. In part two of our new series on the dangers of the university student disciplinary hearing process, we will discuss the dangers of self-incrimination, and we will also discuss the danger that the police or local prosecution can get a copy of the student's confession simply by issuing a subpoena to the university. I appreciate you spending time here at Gustitislaw. Don't forget to give us a thumbs up if you I found our video helpful to you, and don't forget to subscribe. I appreciate you being a part of the Gustitis Law community, and I look forward to seeing you next time at Gustitis Law.